Welcome to the greatest hits of expert opinion letters, evaluations, and the H-1B CAP season. We will provide insights and actionable solutions for the upcoming H-1B CAP season. This webinar is intended for immigration professionals of all levels, and comments by panelists are not endorsements and are not intended to be any legal advice, but a discussion of best practices. Always check primary sources. This is live, so let's get going. Oops. With us today is Fiona McEntee, founding and managing attorney of McEntee Law Group. She was born in Ireland and emigrated to the US and is an award-winning, nationally recognized immigration lawyer who has been featured on MSNBC, CNN, WGN, BBC, and RTE, and quoted in the New York Times, the Irish Times, and the Chicago Tribune, among others. She will provide an attorney's perspective. We are also lucky to have with us Sue Patel, Illinois accredited paralegal with global mobility certification and owner of her own legal firm, paralegal firm called Para Visa Legal LLC. Sue will discuss best practices for paralegals for thriving in the H-1B CAP season. We want to thank Illinois Paralegal Association for sponsoring and publicizing this webinar. I am Jeanette Cherner, Strategic Accounts Manager at FIS, Foundation for International Services, along with Evan Hoover and Rebecca Fuller to take your questions and keep us on track. Quick point of order, if you have a question, please use the question icon and not the hand raise button. And if we don't answer your question before the end, we will do so offline. We will have some polls launched throughout the webinar so we can learn your best practices and share the results later. Today, we will discuss the old registry and the government's goals in creating the new one and how that affects your business. We will discuss the registry process and how to prepare, along with problems and innovative solutions. We will wrap up with Q&A and end on time. So let's get going. Fiona, you're up.
Hi, everybody. Thanks so much for taking the time to join us today. We know that everybody is busy, so we certainly appreciate it, and hopefully you'll get some valuable information here. As Jeanette explained, we're obviously here to talk about the new H-1B system, but before we do that, just to make sure that everybody's on the same page, I think we need to just go over how the system used to work, as in last year and all previous years. So for those of you who work in the industry, you'll be aware that, between January and the end of March, this was our super busy time. This is when we were working on preparing H-1B cases, getting evaluations, preparing the LCAs and so on and so forth. That was all done with a view of getting the cases, the H-1B CAP cases, filed during the first week in April. So during those first, I think it's 5 business days in April, depending on when April 1st fell, all the cases would be filed, and then the CAP was typically met at the end of that week. And then thereafter, no more cases were accepted. What happened next was the lottery would be conducted by the USCIS. Generally in late April, maybe May, premium processing cases, when that was available, we would be notified first. But for everybody else, we basically just have to wait and see whether or not we got the case returned to us, or whether or not the checks were cashed. There was obviously quite a lot of uncertainty in terms of advising our clients, but we just have to wait and see. And then as far as the adjudication timelines, for those of you who were frustrated by the increase in processing times, you'll know that they went well into the next fiscal year. So some of us were waiting well beyond October to even get a request for evidence in our cases. So that's kind of how the system used to work. And I know we're going to be talking now about the new H-1B system. So the big thing this year is the registration. So this all comes from a change in regulations that happened last year. I think it was in and around this time last year. There were two main changes to the H1B system. The first one was the Masters Lottery reversal. So there are, as far as numbers go, there's 65,000 general new H1B visa numbers available, and there are an additional 20,000 numbers reserved for those with a US Masters or higher. In previous years, they used to conduct the US Masters lottery first, and then they would conduct the general lottery. And if you had a Masters and didn't get selected in the first part of the lottery, you'd go into the second general pool. But essentially, that was reversed, and they did the general lottery first, and then the Masters lottery. And the government was anticipating that it would increase the odds. For those who had Masters with this reversal would be, you'd have about a 16% better chance of getting a H1B with that reversal. So that went into effect last year, so we already had seen that. And then this year is the new registry. That was in the regulations last year, but was put on hold until this year. So as far as the timeline goes, we are going to be filing a registration application anywhere between the 1st to the 20th of March. And along with that, there's going to be a $10 application fee. Later, we'll get into what that registration process will look like, but this is just the timelines. So we're going to do a registration first, and then they're going to let us know the USCIS will conduct a lottery, assuming they get more applications. And we obviously anticipate that that will certainly happen. So the lottery will happen, and then those who are selected will then have 90 days in which to file their completed application. So they could file it on the first day, excuse me, or they could wait until later on. But essentially, this is the timeline that we're looking at in the next 6 weeks and thereafter.
One reason for the new registry is savings. According to the Federal Register, and you can see the link there, the H-1B registry will result in savings of $43.4 million to $63.7 million annually for petitioners and the U.S. government. And of that, only 1.6 million of the savings will be for the U.S. government. The rest of the savings, around 40 million or more, will be in the form of petitioners being relieved from the opportunity cost associated with completing and mailing the entire H-1B CAP subject petitions. Fiona, do you have a comment on that?
Yeah, I mean, I guess I would love to see the data behind the figure of that, like 40 million in savings. I mean, we know without a doubt, obviously, there's going to be savings from the government's end in terms of, you know, reducing like personnel costs, less paperwork, less administrative costs, shipping. So the government would ship back every case that was not selected in the lottery. And given that there was over 200,000 cases filed for like 85,000, I mean, that's like a lot of cases to ship back. So I know that there's huge savings there. As far as the other savings, I mean, to assume that a petitioner or an employer will incur no costs just by registration, I don't think is accurate. I mean, from my point of view, we would need to like assess a H1B case from the outset. And that's what we'd be recommending before we would do the registration process. There has to be some analysis done. I mean, maybe you don't prepare the full case and everything with it, but you do need to do some preliminary analysis with regards to the merits or otherwise of a H1B case. So I'm not sure where that exact figure comes from.
Moving on to the registration portal.
I mean, I think it's a little surprising, though, to say that even at this late stage, given that we're about 6 weeks out from the 1st of March, we don't really know where the portal is going to be housed. We are expecting that the USCIS will use the My USCIS online portal, and this is based on information that was received prior and during the beta testing phase. For those who are familiar with the portal, it allows you to online file some forms like the I-90 and 400, very few forms, but it's in that system. We're thinking it would be there. The portal did list H1B registration, but it's not yet active, but that's where we're anticipating that it will be housed. And then as far as this goes, just last week, so kind of hot off the press, the USCIS did publish a notice that said in advance of March 1st, so attorneys and employers will be able to set up their registration accounts. Now, they haven't yet told us when we'll be able to do that. The USCIS said that they will post the data online and that they will also provide detailed registration instructions. Again, did not confirm that it's going to be on My USCIS. This was as of last week. So we are really monitoring this. There's also, we don't know whether we're going to be able to be logged on multiple computers, whether, you know, we should be able to manage multiple client accounts through the same USCIS account. But there is just still a lot of unknowns, which, given, like I said, that there's only 6 weeks left before the registration process begins, you know, it's a little troubling.
All right, and now we're going to hear from our listeners with poll number 1, which is launching. Will you be filing more or fewer H-1B cases this year? If you would vote, and then we can see the results later for everybody. Go ahead and vote. And the poll is closing. USCIS requires basic information, and the list, as you can see on your screen, is not limited to those items that are listed there. This brings up the question, will you be including additional information like an advanced degree evaluation in your preparation or your registration? Sue, let's start with you.
Yeah, so as paralegals, since we work under the discretion of the attorney, it's a good thing to discuss this with the attorneys to see, you know, do they want to get the education evaluations done in advance of even the registration, or kind of wait till after registration and they've been selected for the H-1B cap. I would suggest kind of sitting down with your attorneys and figuring that out. It might be good to get them in advance just because the evaluation companies are going to have so many in that 90-day window. And it's something that is good for the beneficiaries to have anyway. They can use it for other types of cases, even if they don't get selected in the H-1B cap. It's just something they're always going to need for other cases, regardless. I think it's always a good idea to get it done in advance, regardless.
And Fiona, do you have a comment?
I mean, given that we're not really sure what the system is going to look like, we don't know what information, you know, what additional information we're going to be able to include. And later we'll show you screenshots of that we have been provided by the USCIS. But like I said, given that the registration portal is not yet active, you know, we just don't know what information we're going to be able to provide to them. But we do know that there's going to be an attestation there saying that the petitioner, so the employer or their attorney representative, is attesting to the accurate nature of the information that's provided.
All right, so we will launch poll number 2 here, and this is on the question to prepare for the registration. Will you get your application and evaluations ready, or will you be waiting? And we want to know what you are thinking out there. So please go ahead and vote, and we'll let you know the results afterwards. Okay, polls are closing. Fiona, if you could talk about the registry preview.
Sure, yeah. So like I said, this is a screenshot that the USCIS had released, and we'll just kind of go through it bit by bit. So the first is, what is the legal name of the prospective petitioning company or organization? So we'll give the legal name, and then the next is if there's a doing business. So if there's a DBA name, you can put that in, or else select that that's not applicable to the situation. The next is what's the EIN of the petitioner. In Yeah, so I mean, previously, with regards to LCAs and all that, those forms that would have been filed previously, part of the process involves getting the EIN verified with the Department of Labour. I would definitely recommend doing that anyway, ahead of the registration process. And that just reminds me of that because they do specifically ask for the EIN here. And they also ask for the primary office address of the petitioner. So you'll be putting in, street address, zip code, and so on and so forth. So that's the first page that we were given on that. And the next is the authorized signatory's name. So whoever's going to be signing on behalf of the company, their full name, their authorized title, so their title in the company, and then the contact information for them, their phone number and their email address. So typically this is, as you probably know, this is either the HR representative, it could be general counsel, CEO, various different roles in the company can act as signatory for immigration matters, but they're the ones that we would typically see on a regular basis. Okay, so this screen goes into some of the information that we're going to be providing with regards to the beneficiary. So we're going to be providing their first name, middle name if applicable, and their last name, their beneficiary's gender, and we're given two options there, male, female, and so that's the first screenshot. I think there should be another one as well. Okay, the next is asks with regards to the master's or higher. So here we're going to make sure, and it's also important to note that it's not just any masters. I mean, you need to look at the US institution. There's a regulation, or the INA there will show you whether or not the institution is is considered eligible per the master's cap. So that's something that you're going to have to look at as well. And that's it was a big thing for us. There was a trend where they were looking at the masters to make sure that they actually were in the correct lottery system. So you're definitely going to have to look at that. You're going to have to provide the date of birth, country of birth, country of citizenship, and their passport. Okay, and then this is the employer profile that we will see. So you'll see, like, imagine this was for one employer, and then you can see the listed beneficiaries there. So you should be able to add multiple beneficiaries under each employer application. So obviously employers can submit as many applications for different beneficiaries. You cannot, there is obviously a prohibition on duplicate registrations, and the USCIS has reminded us that if multiple registrations are filed for the same beneficiary for the same petitioner, then all registrations for that beneficiary will be invalid. So again, there's a prohibition on duplicate registrations for a H-1B beneficiary.
Sue, can you talk about how paralegals are preparing for the H-1B registration?
Yeah, so as a paralegal, we can only, again, work under the supervision of a U.S. attorney. And this is it's the first year of the electronic lottery, and it's expected that over 200,000 submissions will be made into a brand new system that's never handled this type of volume before. So should something happen to the electronic system, I believe the USCIS will revert to an old paper petition filing and conduct a manual lottery that's like they've done for the past 15 some years. So keeping this in mind, how we as paralegals can help attorneys prep for the upcoming H-1B season really is kind of reaching out to the attorneys and discussing a plan with them. I know I've started sending an email, and these are some of the questions that I've been sending out to the attorneys I work with, just to come up with a plan and kind of get an idea of what all the different attorneys want to do when it comes to handling the registration. Are they looking at preparing the applications beforehand? Will they wait till a case is selected and then prep the cases? When are they planning on getting education evaluations? What kind of information do they want put into the letter of support? Who will be handling the registrations? Kind of going through all of it and figuring out a plan and being proactive.
And one thing that I added to the list there is the possibility of reaching out to your evaluation companies and reserving a space in their queue, because when the floodgates open, they're going to have a lot of cases to take care of. Let's see here. We're going to ask our attendees what they think. We're going to launch poll number 3 here. And so for the registry, will you be filing just name, date of birth, country of birth, employer, and attestation of degree? Or will you file more than that? Are you planning on including perhaps an evaluation or something else beyond just the questions and that are asked by the government? So go ahead and answer the poll question. Polls are open and we'll let you know the results later. The polls are closing. Fiona, do you want to touch on this?
Yeah, so I know Sue had mentioned there 200,000 expected. I don't know where if that number is just based on numbers from last year. But I mean, I'm sure there is going to be a lottery. We don't know what the odds are going to be of the lottery, but I expect that there's going to be a huge amount of registrations given the apparent low barriers to entry here. And I don't know that that's necessarily a good thing. I mean, as mentioned, as an attorney, I think it is prudent to assess the validity of the underlying H-1B petition from the outset. And this, to me, would include reviewing the job description, reviewing the offered wage, pulling the prevailing wage, determining a stock code, reviewing their education, getting an education evaluation or an equivalency one if necessary, and making all that assessment done from the outset. I mean, you don't necessarily need to have all the forms prepared and ready to go, although you could do that if you wanted. I think we're going to give clients the option about preparing whole packets ready to go if they get selected, so that on April 1st we could file straight away. You know, again, as I mentioned, the fact that you have 90 days doesn't mean that everybody can wait until the 80th day to submit the case. I mean, there might be a reason that you might need to get that case filed, you know, shortly after April 1st, like for instance, the cap gap that I mentioned previously. And then, as Sue alluded to, I mean, I am very concerned that the registration may not go as planned. Sue and I had experience of working with the H-2B registration system on New Year's Eve of, not the New Year's Eve just gone, but of the previous year. And I'll just recap what happened there, but essentially the Department of Labour requested everybody to file in the system, and for H-2Bs they were going to time it down to the millisecond. So essentially everybody was on right when it opened up on New Year's Eve. I think it would have been like midnight Eastern time into New Year's Day, which is when it opened. But so many applications, so many people were on, so many applications were trying to be submitted that the whole system completely crashed. And it crashed for, Sue, how long was it? It was for a month or so, or at least a couple of weeks.
Yeah.
Yeah, so
it was about
a couple of weeks, you think? Yeah, so the system was frozen, broken based on the sheer volume of people that were trying to get on and register for H-2Bs at that time. Now I know the government didn't say that everybody needs to get on and they're going to time it down to the millisecond, but still it is a new system. So we're just not really sure how it's gonna go. I am concerned that what if the system doesn't work as intended and then they need to revert back to the old way? Would we have enough time to prepare the case for filing on April 1st, including getting the evaluations, getting the LCA reviewed, posted, and then submitted and certified? So look, there's a lot of unknowns here, and I think our job as lawyers is to try to anticipate some of the worst case scenarios and to try to prepare and advise on risk, and then options, and kind of give clients the option of either preparing everything as normal as you normally would and having everything ready to go, or waiting. So it's just, I think each attorney, each paralegal will have to sit down with their clients and figure out what makes most sense for the clients.
All right, we're going to move into evolving solutions and strategies. When filing completed applications, there are some options that we have seen that cut down on RFEs, and these are strategies we have seen attorneys and paralegals use. First off, have the foreign degree evaluation and the expert opinion done by the same company, a NACES company, because NACES is approved by the U.S. Department of State. Regarding expert opinions, we do a lot at FIS, and some of our expert opinions we do are filed with the original application. And we are starting to see more of our expert opinions for large law firms that require a professor phone call. So as part of the expert opinion, a professor would call the employer and provide firsthand knowledge to USCIS about the job and workplace. Make sure to have your expert do a clear comparison of OOH and job duties, along with how that matches with the college transcript. That will make it easier for USCIS to see how those all relate to each other. We're going to launch poll number 4 here and see what our attendees have to say. Do you have your evaluations done by the same company as your expert opinions? Or is that something you haven't thought of before? So go ahead and vote. And we'll close that here in a second and we'll let you know the results. Okay, moving on to the next slide. There's another thing that we have seen attorneys do to avoid RFEs, and this is following the rule of don't file too broadly. So some attorneys, they limit the fields, and if they have a mathematician, for example, they may choose terms like statistician and avoid computer system analyst. And since the term market research may be a problem, they may choose SEO position and provide similar job postings. These are the types of preferences we have seen attorneys do. Fiona, do you have any comment?
Yeah, I mean, I think that we all know that the dreaded like specialty occupation request for evidence is, I think they're coming more often than not now. The RFE rates are well over 50%, I believe, for H1Bs, and I could pull up the data and see exactly what the latest rating is. But basically, the chances of getting requests for evidence are extremely high. We can sometimes see trends as they're coming down with regards to certain occupations. I would agree with not filing too broadly in terms of like listing, lots of different fields of degrees that could be, that could qualify an individual for the role, and that kind of goes against the specialty occupation, or how the USCIS is interpreting the definition of specialty occupation. And so I would say keep an eye on trends. It can be actually also very frustratingly subjective. So we've had a situation where we filed for an operation research analyst for the same company. One case gets approved, the other case gets denied, and they're pretty identical positions, everything else is equal, except for perhaps the reviewing officer. So the denial rating is also extremely troubling. It went from about 5 or 6% to over 30% last year for new H1B cases. And this is despite the fact that there was no change in law, and there's just a change in adjudication standards. So it is something that is pretty troubling.
How about you, Sue? Do you have anything with regard to that, with regard to what you have seen attorneys do? Any trends?
Yeah, when it comes to using kind of like what you said, the, market research one or financial analyst, I know that was an issue that kind of kept coming up last year. And one of the things that I remember last year is whenever we had to use those, kind of providing extra information. So similar jobs that also required at least a minimum of a bachelor's degree that were also in the same title helped a lot, I think, and kind of showing, it is a normal trend to have a, minimum of a bachelor's degree for certain SOC codes, and kind of just proving your point in the argument using the OOH and using ONET also to back it up also was something that helped in the letter of support. I think adding more to the letter of support to beef those up doesn't hurt at all.
Very good. Okay, we're going to launch the final poll. So here it is. What new ideas are you considering implementing? And there are a couple options there about reserving space with your evaluation company, professor phone calls, and contacting your clients to see how many cases they expect to register and file, and discuss your strategy with your clients, including the possibility of different visas, which we're going to get into next. So go ahead and vote, and we'll let that be open for another couple seconds here, and then we will be closing the polls, and we'll move on here. The H-1B evolution continues because DHS has proposed to revise the definition of H-1B specialty occupation, the definition of employment, and what is an appropriate wage. Will that mean your clients will want to file for different visas? And go ahead and comment on that if you would, Fiona.
I mean, I think that the H-1B has been under attack for quite a while, as we've seen with the extremely high request for evidence ratings for positions now that would, in my mind, be like a no-brainer H-1B, like, for example, a mechanical engineer. We're seeing specialty occupation, requests for evidence for these types of roles, and it is extremely frustrating for our clients. Also having to prove like a senior software developer with like 20 years of experience, having to prove that that is a position that requires at least a bachelor's degree in a specific field. So these are the types of things that we're seeing with historically, I would say, clear-cut specialty occupation categories are under attack. And, it's a waste of time, resources, money, energy, everything really for our clients. And so to think that there's, that there's some revised definition coming down the tracks, or, prevailing wage, we're not really sure, but I guess I'm not surprised to hear that there are more changes coming to this option.
And Sue, do you have anything with regard to that? Are you seeing other visas that your clients are looking at?
Not really. Again, working under the discretion of an attorney, I kind of let them do that assessment and see what they've discussed with clients, and just wait for them to tell me what to draft.
All right. Here is a partial list of some categories for visas. And Fiona, I believe you have a couple that you like to use in place of H-1B at times.
Yeah, I mean, there's some here that we would use. We, at our firm, we file a lot of the O1 visa. So that's for individuals with extraordinary ability. I would say that a lot of times people think that this is just for people in the arts and entertainment industry, but that is absolutely not the case. And I spoke at AILA National Conference last year. I led the discussion on the O1 visa and the green card version of that. I'm also speaking at the Chicago AILA Conference in March, and then at the AILA National Conference in San Diego in June this year, again about these options. We've successfully filed O1s for software developers, for, co-founders, for people in business. So other options that you maybe, for individuals that you might have considered a H-1B for, look at the O1. There are other options there, different types of J1s depending on the specifics. There's J1 intern, J1 trainee, J1 research scholar, lots of different potential options. E2, I don't think that's there, but E2 or E3 if the person's from one of the treaty countries. And then also green card options as well. I think people are more often looking at green card options to see whether there is something that would work for them there.
Can you tell us a little bit more about green card options?
Yeah, so I mean, it's depending on, again, every case really requires an individual analysis. But in the employment-based green card options, there's three main categories. So there's the EB1, so EB is the employment-based first preference category. Then there's a second preference category and the third. And then within those, there's subcategories as well. So the EB1A is for individuals, that's like the corresponding to the O1 extraordinary ability, and then a few other options, a multinational transfer, like the L, that's the EB1C, and then outstanding researcher and professor is the EB1B, and then EB2, EB3. A lot of times that goes through the perm process, but there are some exceptions to that as well for professional athletes and Schedule A workers. So there is a lot to unpack with regards to green card options, but I think it warrants an analysis with a client to see if there is a green card option that might work for them and for their employee. Unfortunately, if they're from a country that has a backlog in the employment-based green card, a significant backlog, it might not be feasible for them. It certainly won't give them an immediate option. But in any event, I think it just warrants exploration one way or another.
And what else are you keeping an eye on with regard to the government that you see is a trend or something that you're just being aware of?
I mean, I would say that it probably won't come as a surprise to hear that, there have been, the scrutiny has increased really across the board in the business, employment, immigration context as well. I mean, a lot of times people don't really get to hear about this type of scrutiny in the media. Maybe that there is more focus on, there's just a lot of immigration angles to cover in the media, so not everything gets heard, right? But what I would encourage people to do is it's really important to make sure that they're keeping up to date with the changes and trends. For my resources, so I'm pretty active on Twitter. At US Visa Lawyer is my handle, and I will follow very reputable sources like AILA, which is obviously the American Immigration Lawyers Association, the American Immigration Council. I think FIS is on Twitter as well. But Sue, I don't know if you're on Twitter or not, but basically it's in our interest to keep up to date with the changes and trends and to think about advocacy in different ways. And so that's kind of one of the things that I'm kind of teaching my clients. And also I did a presentation for the Illinois Paralegal Association about looking at creative ways to reach into the toolbox and just look at cases in different ways and to try to be the best advocate that we can be for our clients. We need to bring some creative approaches to the cases, especially right now we're in probably the most heightened level of scrutiny that we've ever seen. So there is an obligation on us to really be the best advocates that we can be for our clients.
That's wonderful. Well said, Fiona. Appreciate that. And to our audience out there, do you have any questions that you would like answered? If you do, go ahead and click on to the questions portion there and send it along, and we'll send it to Fiona and to Sue. And Sue, are you seeing any trends out there that you are, I know that you work for attorneys and you may just be reacting to what your attorneys are saying, but is there anything that you are seeing out there?
Yeah, I'm starting to see a lot more green card cases that are based, before in the past, usually most green card cases came out of Ls or H-1Bs, and I'm starting to see, as of last year, green cards starting for people who are on S or other kind of visas and not necessarily just H's and L's anymore. It feels like, because it is so hard and there is so much scrutiny with a lot of the non-immigrant visas, that people are kind of jumping to the green card. And I'm also starting to see an uptick in green card cases for people who aren't even in the U.S. yet. So people are kind of skipping for ones that don't have backlogs, the non-immigrant, and kind of going for the green card and, waiting till it's approved and then bringing the employees over. So I have been seeing a lot more of those types of cases coming through.
That is really helpful. That's really good to know. And I believe that we have some information on the polls, and I'll share them with you here. So the first one we have, Evan's going to share them. In fact, I'm going to ask him just to click on and do the audio on it and share the polls, if he would.
Yes, hi, Evan Hoover here. For our first poll, it looks like we got a little split of all the polls. 56% of attendees answered them. So these are the results. We're going to move on to the second one.
So we have 3 of them that we've seen. Are there 2 more? Is that it? Okay, 2 more are coming. And if you don't see them on your screen, we can send this information to you afterwards so that you can see what your colleagues are doing. And as always, if you have questions, we're here for you. So let us know. Okay, so we've made it through all 5 of our polls. Thank you, Evan. That's very helpful. Okay, on to the end here. We want to thank everyone for joining us today. We really want to thank Fiona McEntee, Sue Patel, and I've been here with behind the scenes help from Evan Hoover and Rebecca Fuller, and my name is Jeanette Scherner, and we're from FIS. And we look forward to staying in contact with you if you have additional questions or want to brainstorm strategies. We wish you all good luck with this upcoming H-1B CAP season and hope you have a great week. Anything else you want to say, Fiona and Sue?
I mean, I would just say to maybe expect the unexpected. We just don't really know. A lot of times the government, the USCIS, they don't really give us a huge amount of notice for things. And we've seen that with whether it be, you know, memos coming out just before CAP filing or the removal, the elimination of premium processing as an option and then adding it back in very quickly just before CAP season. So we've learned to expect the unexpected, and you know, it's hard to say how this is really all gonna go down. We will just have to watch this space, but I think as far as timing, the next couple of weeks are going to be pretty critical because this is when we're going to see the new system, be able to get in, be able to register it, or to like at least put in the employer information and kind of see the glitches. But I don't know. We'll just have to watch this space and wait and see what happens from here.
Thank you.
And
All right.
I just wanted to expand on, Jeanette, that you said sitting down or, you know, kind of brainstorming strategies. I've actually sat down with FIS and kind of brainstormed strategies and expert opinion letters, and it was extremely helpful. And I walked away from that meeting just, you know, sitting down and talking with somebody from FIS of different ways to use expert opinion letters into our cases or even RFEs that I didn't even know were options before. So I think even brainstorming and sitting down and talking to you guys was super helpful in that stage and coming up with other ideas of how to address, you know, H-1Bs from that get-go or different ways that we could tackle an RFE once we do get RFEs for H-1Bs.
Oh, that's wonderful. Thanks so much for saying that, Sue. That's what we're here for. We're always doing evolving solutions. That's what we pride ourselves on, being innovative, trustworthy solutions for you and a place to brainstorm because nobody has all the answers. And we're always learning from you. we're adapting, we're expanding our professors all the time and what they provide. And like I mentioned, we do that firsthand information when they contact, they do the phone calls. So we're here for you, and we look forward to helping you through this season. We just wanted to connect and make sure that everybody is on the same page and that we can all share resources and help. And we really appreciate everybody's time today. Hope you had a good time, and look forward to seeing you at the next webinar. Thank you.
Thanks, everybody.
Thank you.
Bye-bye.
Bye-bye.